Okay, we'll get started. I'm sure people will continue to join as we go. But welcome everybody. I am Nick and I head the employment team at Actons. I know there's a number of people on the call who we already work with and we know. If you don't know us, we're based out of Nottingham city centre. We work with clients all across the UK and focusing in on the East Midlands, given that's where we're based, a range of SME clients and some household names that you will have heard of, some of which are on the slide there. We cover the full range of employment law services that you would expect, and that ranges from things like employment contracts and handbooks, policies, procedures, all that kind of basic stuff, through to more complex things like employment tribunals, managing sickness absence, TUPE, all that good fun stuff. We have a fabulous team who are there. Do connect with them on LinkedIn. If you scan your smartphone camera over those QR codes, you'll be able to connect with the team there. And we use LinkedIn a lot for those of you that are already connected with us will know that, to share updates. And of course, lots changing at the minute with the Employment Rights Bill passing through Parliament, and it is pretty intense in terms of the changes that are happening there. And we try and keep people updated that way. So do connect with us there. It would be great to follow you on LinkedIn too. And in terms of what we offer work-wise, obviously we would love to work with you if you are in need of employment or HR support. This kind of little brochure will come out to you after the session by email. But yeah, we'd love to stay connected with you. We'd love to help where we can if you're in need of that support. The other thing that I wanted to flag, and I have the pleasure of hosting, is something called the HRD Talks podcast. And the latest episode is a cracker with Jan from Marston's. She's incredibly open about her kind of career journey, her own kind of struggles with mental health issues. And she talks a lot about trust and leadership and change. And obviously restructure is the topic for today, is one of those kind of pretty significant changes that can happen in a workforce. So if you are interested in that topic, do check it out. You can find it pretty much everywhere: Spotify, Apple podcasts, and you can ask your device. I won't say the name of the device that might be in your house, otherwise it'll start playing in the background. But yeah, you can ask your smart device to play it as well. And so yeah, we'd love you to check that out. In terms of the plan for today, we're going to look at kind of three areas. First of all, our starting point, as I've kind of highlighted already, is the Employment Rights Bill. Now, we're not going to major on that in every area, but there are some changes that are relevant to redundancy restructures, in fact, pretty fundamental to that, which we'll look at as part of the session. But obviously, we're going to look at how to manage these kind of processes as well too. So it'll be the redundancy process, the restructure process, and some on the Employment Rights Bill. And I'm going to kick us off with the kind of context for this. So you probably will have had to be under a rock to have missed the fact that the Employment Rights Bill is coming. That said, a lot of people are not doing much about it yet because it's not law and because actually lots of the detail hasn't been finalised. The bill came out last October, and it's essentially the Labour government's plan to make work pay. And it has a number of stated objectives, which are all very laudable, but it is going to significantly change the kind of the workplace and the landscape in terms of legislation. You know, I think it's being heralded as the biggest change in at least a decade, if not longer than that. What I would suggest, sorry, going back a slide, is if you're interested in kind of the stated objectives, I wouldn't go anywhere near the bill. It's very, very long, and in fact, it's got longer as the months have gone on and more has been added and amended. What I would suggest is having a look at that red document with the lady hanging on the side of a building, which is much more accessible and at least is the starting point as to what the government were trying to achieve. So do look that up. In fact, James might be able to find it keep him on his toes and post it into the chat. There's a challenge for James before he has to speak. So you have a link to that there, because it's probably the most accessible bit that you can look at. The first area I wanted to highlight today, however, that's relevant to what we're going to talk about, is unfair dismissal day one rights. And most of you will know that in order to claim unfair dismissal, at the minute you have to work somewhere for 2 years, and that is fundamentally changing under the new legislation. The chances are this won't apply until the autumn of 2026. But people are starting to plan for it now, and clearly it's relevant to redundancy as well as all other types of dismissal. So we're just going to look at it briefly as to how that's likely to apply. So effectively, unfair dismissal rights will apply from day one, and therefore you won't have to have worked any period of time with the employer to be able to bring an unfair dismissal claim. The idea will be that they'll introduce a new concept called the initial period of employment, a bit like a probationary period, but not a probationary period. And within that initial period of employment, there's likely to be a kind of modified dismissal procedure that's different from the procedure that applies after that initial period of employment. We don't know what that will actually look like yet, because we don't have the detail of that. And that's likely to follow in regulations, but we expect it will likely be invite an employee to a meeting, tell them why they're being dismissed, write to them confirming it at the very least. The tricky bit about this so far is that we don't have the detail as to how long that initial period of employment will be. The government preference appears to be 9 months, so it'll be a reasonable period of time that will apply. And there'll be an interesting interaction between that and probation periods, which tend to be 3 or 6 months in employment contracts, and working through how best to manage that set against a new concept of initial period of employment will be interesting. The other thing to keep in mind is that the compensation regime, so if someone does bring a claim and are made an award by a tribunal, is likely to be different during that initial period of employment as well. Bringing it into the redundancy arena, the light touch process that I talked about there in terms of the initial period of employment, or the IPE, will require the employers to reference a reason for dismissal. So that's usually conduct capability, statutory restriction, which is illegality, sorry, I should say, or some other substantial reason. However, redundancy is excluded. So employees made redundant during that initial period of employment are likely to have the right to claim the kind of full unfair dismissal from day one. So that's why it's helpful just to reference what might be coming there with redundancy, because it's slightly different to the other types of dismissal that you might be considering with employees. So moving into the meat of the session, we're going to look at some of these areas, the redundancies, the restructures, and we're going to focus on collective consultation as well, because there's some changes there that James is going to pick up. One of the things that I wanted to do just before I hand over to Laura to talk you through the kind of fundamentals of redundancy was address a kind of a planning or a timing query that we get quite regularly from clients and who maybe haven't done this kind of process before, in terms of how long things can take and the kind of basic process for doing this. So I'm mainly talking here about individual consultation rather than collective, and James will talk through that later on. But the starting point for nearly all of this stuff is what I describe as a business case for making redundancies. So it's super important that actually that's robust, that's been thought through, that we understand the background as to why we're having to let people go for redundancy reasons. And sometimes that's very clear, sometimes it's not quite as clear, and it needs to be articulated well. But sometimes it's so clear to people that actually there's no kind of audit trail as to why we're doing this at all, because it's just obvious to everybody. But actually writing it down in a document, a one-pager, is pretty fundamental in terms of demonstrating why you've decided to kick off this process in the first place. And that's helpful for an employment tribunal if you ended up there, if somebody challenged their redundancy. it's also helpful for the individuals involved in the process to see the background and the reasoning as to why this is happening. So it's pretty fundamental that that exists, and it's going to really be the foundation, I suppose, of the entire process. The other thing that often we come across is employers who are very keen to get this over and done with quickly, and we understand that it's not a nice process to go through generally. It's not a nice process to put people through. But in reality, consultation takes a bit of time. That's the point of it, that you're talking to your employees about what's happening, getting their feedback, and consulting about the changes that are taking place, why it's happening, alternatives that might be relevant. And we're going to look at that kind of detail as we go through the session. That takes some time. And I guess my take on the timescale for this stuff is, generally speaking, it's going to be at least a 2 to 3 week process. That generally involves people being put at risk, so being told that their role is at risk of redundancy, a couple of consultation meetings so that you can properly discuss that with them based around the business case that we've talked about, and then usually a dismissal meeting at the end where you confirm, well, I suppose either that they're dismissed on grounds of redundancy, or that actually the alternatives they've come up with have saved their role in some way. Again, unusual, but does sometimes happen. So hopefully that's helpful in terms of kind of practical overview of the basics of running that process. I'm going to hand over to Laura, who's going to take you through some of the fundamentals when it comes to redundancy.
Morning, everyone. So we're looking now at what a redundancy situation is. Redundancy is defined in law. The legal definition is quite wordy, so I'm not going to take you through what that is, but you'll see that there's 3 broad categories that it falls into. So there's business closure, which is what it says. A business closes as a whole, there is no more, therefore the employees are redundant. There's the workplace closure, so if a workplace, not a business as a whole, goes, so maybe a shop of a larger chain, then the staff at that particular shop and that particular workplace are potentially redundant. And then a reduced requirement for employees to do work of a particular kind, so that could be the type of work that they do for you or the location of where they work for you. So you'll see that when you're facing an unfair dismissal claim, the burden is always on you as the employer to show that there was a fair reason for the dismissal. So the fair reason that we're looking at in these slides is redundancy, which is a potentially fair reason for dismissal. The test for unfair dismissal has a couple of stages. So is there a fair reason for dismissal? As we've just said, we're looking at redundancy here, generally speaking, provided that you can show that there is a genuine redundancy situation. E.g., we're not just covering up what the actual situation is, or it's something that we've just spoken about. So one of those broad categories, you're likely to be okay on that one. And then it's the second test is for the tribunal to decide whether dismissing for that reason of redundancy is fair or unfair. Case law has helped guide on how they assess that fairness, and they've established 3 guidelines on which are the things that are on the screen here. So generally, an employer won't act reasonably. For example, they won't usually be held to have made a fair decision unless they've done these 3 things. So warning and consulting, and Nick's just touched on this a little bit, talking about the proposed redundancies with those affected. Adopting a fair basis on which to select for redundancy, so identifying selection pools or fair selection criteria to score those employees against, and then considering suitable alternative employment. So are you as the employer looking for what alternatives are out there, and are you actively making them known to people before you're making decisions at the end of the redundancy process? Consultation. So what is consultation? I think it's a word that we'll have all heard a million times as we're talking about things like redundancy and restructures. But the main thing is consultation is a 2-way process. So it's you guys as employers and the employee's opportunity to tell your side of the story and their side of the story, and discuss and consider each other's point of views. So it's not simply, well, we've called them into a meeting that we've labelled as consultation meeting, we've ticked it off on the box, we've done that bit now, next. There are a few different ways that consultation can take place that you'll see as collective, individual, or both. I think there's some slides later on that the guys will be talking to you about collective in more detail, so I won't go into that just now. Individual, as Nick has just touched on, pretty much every redundancy situation that you come across will require some form of individual consultation. So, like I just said, the key thing is remembering that it's your opportunity as much as theirs to discuss the proposals and what may happen. And as Nick's just touched on, it's explaining to them what is happening and why, considering any points they bring to you and responding to them. And one of the things that we do quite often see when we get a case that involves stuff like this is an employee has raised questions or an individual has come and said, well, what about this? Why is this happening? And it's either just missed, not picked up, or they're referred back to a generic fact sheet or post that actually doesn't answer that specific and niche point that the individual has raised. So treating consultation as that back and forth conversation. The employee has asked this, we've considered it, these are the things we've considered, and this is why, and we've told them why, is a fairly fundamental part of consultation. Timing and length, Nick again has just touched on. There is no set timing or length for most everyday redundancy consultations, subject to what the guys will talk about later in specific situations. As Nick said, we usually say that trying to cram everything into less than a couple of weeks is an unrealistic target, and you're mainly looking at 3-4 weeks, but obviously that depends on the complexity of the situation that you're doing, and various other things, which will be covered in a bit more detail later on. So during the consultation, what are you discussing? What is the subject matter of those meetings? So selection pools and selection criteria, discussing with those affected how the redundancy pools have been put together and why, even if you think that's obvious. So even if you're sitting there thinking, well, clearly they're in that redundancy pool because that is their job, that is the pool we've put together. It's not always that obvious to someone going through the process. It's not always that obvious if actually they've got other things that they want to raise with you and ask. So having that conversation with them and explaining to them, this is how we've come to this pool, this is how we've come to this selection criteria, this is how it's going to be applied, and just taking the time to talk to them about that. And as the process goes on, making sure that you are discussing with the individuals how that's going and if there's any changes to it as a result of consultation. So giving them an opportunity to challenge or ask questions on the pooling or criteria and their placement against it. So at a consultation meeting, being ready and prepared to discuss and explain why they've scored what they've scored, and how that score has been reached. And as I just mentioned on the other slide, if someone does ask questions on the hows and whys that something was done in a particular way, go back to them, document that in the notes of a meeting or in an email, and explain why it's been done and why you as the employer consider it fair to have done it the way that you've done it. And that might be helpful, as Nick said, if it's challenged in the future, having that in the background. So one question that we quite often get asked is, do employees need to be provided with details of how they were scored? The simple answer is yes. We'd always suggest that they are given the details of their scoring against the criteria and a background explanation as to why they've come to that. So rather than just saying you scored 5 in this area, okay, well, why did they score 5? How was that calculated? We'd also suggest that at the very least they're provided with information that tells them where the cut-off point is. So if they're in a pool of 10 people and the proposed situation is to reduce headcount by 5, are they in the top 5 that may be potentially safe, or are they in the bottom 5 that potentially are the most at risk of redundancy? One thing that happens in redundancy consultations is that people fall into the trap of thinking that everything needs to be discussed in those set few meetings that Nick just outlined there, and if a question comes up that you can't answer, it just gets missed, because by the time you get to the next meeting, you're on the next planning stage of that process. So it's just being open to considering the fact that as the process goes on, it really is a two-way moving process. And if that means that an employee has come to you with 2 pages of questions that you can't immediately answer on the day, a whole pack of documents that they want you to look at because they think that this would change their scoring against the criteria, take it away, go and speak to whoever you need to speak to, whether that's their line manager, other people that were involved in the scoring, whatever you need to do, and either being prepared to go back to them at the next meeting with, thank you very much for bringing us in, we've had a look at this is why, or an email or letter in the meantime that says, thank you for these questions, I've been away and had a chat with these people, this is what I found and this is why the scoring remains as it is or has changed. So alternative employment, we mentioned there's a duty on you as the employer to consider and look at whether there is any alternative employment available. Providing sufficient information is sometimes one that's easy to fall down on. So quite often we will see a list, particularly in large-scale redundancies or restructures. Here's a list of all the jobs that are available. Here's a link, and not any signposting to any further information about that. Now, that is a good starting point, having them all in a list that you can give to employees, but it's then going above and beyond that. So wherever possible, we suggest taking a more proactive step, and not only providing that list, but specifically pointing employees to roles on the list. So is this a similar role? Is this something that's similar to what you currently do? And being ready to answer questions on what the jobs in that list are. So who should they contact for further information? If it's a restructure that's leading to the redundancy, if there's introduction of new job titles or responsibilities, being able to explain what they are, and things that you as an individual would want to know if that was you in that situation. So who will it report into? How will it differ from my current role? What's it intended to be? Is it an office-based role? Is it a remote role? Is it a hybrid role? All of those kind of things that you think, well, actually, these questions are going to be quite important. So they can't take that from a list that says there is a job in Manchester. They need to know more details of what it is and whether it's actually something they're interested in. Because otherwise you run the risk that they say, I didn't know there was anything that there was any alternative jobs. No one told me this. That list was just there for ticking a box. So making that proactive, here's a list of things and this is what they are. And that includes using knowledge of your employees and their skills and strengths to match vacant roles, as you'll see, with potentially redundant employees. So that might be thinking outside the box. If you've got someone that's got a particular skill set in the area of the business that is going, could those skills be transferred? Could they be used somewhere else in the business? Could they be upskilled to another role that actually wouldn't cost the business a lot of time and effort, but keeps them in a role within you guys, and having that base level actually is helpful to you and them. So then you'll see, should an employer consider bumping? You might be thinking, what on earth is bumping? If you've not heard of this before, don't be alarmed. It's not something that comes up in every single redundancy consultation, but we have seen it, and it does come up. So bumping essentially means moving someone who is currently at risk of redundancy, so we'll call them employee A, out of that and putting someone in who isn't currently at risk of redundancy, so employee B. So to try and put that into context, employee A could be someone who's very, very senior, right at the top of the corporate ladder, and it's that top level that's potentially redundant. And they come and say, well, actually, I'm thinking of taking a step back. Can you not bump out employee B at the bottom of the ladder? I'll go and do that role, because there's less responsibility, there's less time for me to be in the office, there's less time for me to be doing these various things, and actually I keep my job, so just bump them out for me. You might be thinking that sounds terribly unfair, that someone can just come and say, well, you can just bump this person out of the role and I'll take that. But it is something that unfortunately does happen and people do, and you should be alive to it, because the tribunal will expect you to have considered it. And particularly if someone's coming to you and saying that, don't just dismiss it as, well, what a ridiculous suggestion, why on earth would we do that? You need to be going away and having a look at it and thinking it's another query. You treat it the same way as you would any other question that someone brings you during the redundancy consultation. You take it away, you think about the pros and cons of it, you come up with an explanation as to what you've thought about and why you've made the decision that you will or will not consider that as an option. So I'm now going to hand over to James.
Thank you, Laura. I thought I'd frozen for a second. I don't think I have. I'm going to talk, if I move the slide on, about fair basis for selection, which, just going back a few slides, as Laura and Nick alluded to, I think in Laura's section, if you're defending a unfair dismissal claim where you've made some redundant, the first part of the fairness test and the old case of Polk again is, did we warn and consult as the employer? Laura has covered that. The second stage, was there a fair basis for selection? I'm going to cover in a bit more detail, just because it's usually the one that's most important, because it's more critical to the outcome from a practical perspective of whether person A who's bringing the claim was made redundant or wasn't. Often the warning consulting is criticised, but there's an argument of how much difference did that make. Whereas if it's to do with the picking of the people, then it could be more of a critical issue, because the employee may be saying, well, you shouldn't have picked me. If you'd have done it right, you'd have picked them and they would have survived. So that's why we're looking at that. So what do we need to do to achieve a fair basis for selection? Is going back a stage back into Laura's section. Before you even start consulting, you need to identify appropriate section pools or consult on those appropriate section pools right at the outset. How do you do that? going back to logical first steps, consider what type of work is actually ceasing or diminishing. So why do we have a redundancy situation in the first place? Then consider what extent employees are doing similar work. Often it's attractive, as the sort of second bullet point says, to do a narrow pool, but I always advise that you need to put your employee hat on and think at the consultation meeting, what are the employees going to say? Why didn't you pull me with these other people? Why did you do it this way? So if you think that through at the beginning, at least when you get to the consultation meetings, you can put forward why you're proposing to do it one way or why you did do it one way, and have your reasons thought through before you start. There's nothing worse than being caught on the hop, having not done enough planning before you start. Interchangeable jobs, Laura sort of alluded to that. That can be a really tricky area. If people do interchangeable roles, the safer approach is to have a wider pool for selection. But you might not want to do that for various reasons. So it's working through why you're doing it and considering all the variables before you get going. The overriding fairness rule that tribunals apply is our old friend, the range of reasonable responses. So often there's more than one way that you could pool your workers that's fair. You just have to consider whether whichever way you're choosing is one of the reasonable ways an employer could have done it. Does the way you've chosen fall within the range of reasonable ways you could have done it, or would no reasonable employer have done it the way you're proposing to do it? And that brings us on to pools of one. There is case law that says pools of one can be fair, as is the beauty with employment law. I couldn't possibly say it will be fair in any given circumstance. We'd have to assess why and look at the reasoning as to why you're pooling at is one. Pools of one are often the most highly scrutinized because from an employee perspective, you've probably all come across an employee saying, oh, I've been targeted for redundancy, or it's not about the role, it's about me. And again, you need to be prepared to address such arguments during the consultation process and really justify why you've done a pool of one, because you're going to be scrutinized more with a pool of one from both the employee probably during the internal process, and then if it did go further by the employment tribunal. Once you've got your pool, the next area that often is scrutinized is the selection process. One way to select between potentially redundant employees in a pool is to apply selection criteria. I'm not proposing to go through the years and years of case law on this area. It hasn't really changed much in the last sort of 10 or so years. But as you probably all know, ideally the scores should be measurable and capable of independent verification. So not just the opinion of one person. And as I've suggested on the second bullet point, it assists if the person who's doing the scoring is able to point to things that already exist when making their selections, because then it becomes much harder for the employee to say, well, that's not fair, because this person is just using information that's already there, such as things from performance appraisals or HR records like attendance, disciplinary warnings. Purely subjective criteria, things that are very sort of vague, attitude, can be quite difficult to justify because it can be a matter of opinion. So that they're to be avoided if possible. And I've suggested that you are cautious on the issues of discrimination. Quite a lot of criteria can potentially be discriminatory, whether it's absence because of someone's disability or pregnancy-related absence. Or there could be other criteria that impacts or is impacted upon by criteria. So you just need to be careful when you're designing the criteria that you mitigate any disadvantages people have because of a specific protected characteristic within the way it's applied. So to go back to my example, if you were using attendance absence as a criteria, which is a perfectly reasonable thing to do, if somebody has disability related or pregnancy related absence, you might want to be thinking about whether those absences should be disregarded for the purposes of the selection process. Selection criteria, certainly from my experience, a lot of employers aren't a big fan of it because some of those categories I just mentioned, disciplinary procedure, attendance, may not be the most critical attributes that you want to retain when you're doing your redundancy process. And for perhaps higher paid, more higher skilled jobs, it can perhaps lead to a role where you don't necessarily get the people who are best suited for those roles. So you don't have to use selection criteria. You can do other types of selection interviews or exercises. The law just says you have to adopt a fair basis for selection. It's not required that you do it in any particular way. But similar principles apply if you use some kind of exercise or interview. I've suggested that you still have scores that are capable of verification. So if you're interviewing, you give someone a numerical total. And one way you can do that is by having questions with model answers. So that it's easy, you can keep notes, record why you've given someone, say, 3 points for question 2 as opposed to 2 points for question 3, so that candidates can be fairly compared to one another. And consistency of process is key, so that when person A says it's not fair or it's discriminatory, person B was scored this and I was scored that, the manager who's giving evidence to the employment tribunal can sit there safe in the knowledge that their notes are clear. This person got a higher score on this question because they answered it better. They said this, which was within the marking scheme, and this person did not. And it's very difficult then for a tribunal to go beyond that if it's all documented and fairly noted down. You might think that that could be quite difficult, and I'd agree. Preparation is key, and in terms of managers conducting interviews, if people aren't used to doing that or they're not used to doing selection exercises as part of a redundancy process, then you might want to think about training them in advance, because often these processes go wrong. They're designed well, but the managers who know the employees who are at risk, who end up doing the selection, aren't actually party to the training or aren't experienced enough in those areas. So it can be something to think about before you get started. Who's going to do what? Are the people that we need to be doing the various stages of the process familiar? Do they need any assistance themselves before they get bogged down in the process itself? And as I say, record keeping is critical. We always have one eye on the possibility of an employment tribunal, and this is potentially a sort of a growth area in claims, because we're moving from the world where anyone bringing a redundancy unfair dismissal needs 2 years employment to an unknown amount based on the initial period of employment length and whatever the light touch means for the purposes of redundancy. So it could be quite a big thing that's a growth area, and it might be that you get fewer discrimination type arguments and more classic redundancy arguments, because it's easier for people to pursue those types of claims and under the new regime once it comes into force. Alternative employment, Laura already said a lot of the things that are mentioned on this slide, so I won't labour the point. I think the most common error I see employers make is that they think this is more of an employee problem, in that they just provide a list or they suggest that there are roles and that they should make inquiries. That's not necessarily good enough. The duty is on the employer to look for alternative employment. So even if there is nothing, have a conversation about the nothing. Say, we found this list, we've looked at it, you do X, these vacancies are Y, we don't think they're suitable. Do you agree? And then, of course, if they don't agree, then you've cornered it off. And if they do, great. An area where you can fall down is where the employee just is so upset or annoyed about being at risk of redundancy that they just sit silently through the meetings, and they get dismissed. And then after the fact, when they put in their ET1 to the employment tribunal, they start saying, well, they didn't do this and they didn't do that. And it's never that attractive a defence for the employer to say, well, they never made any of these points at the time. Because if you were saying, well, we engaged with them and they didn't make the points, that's a lot better. So I'd echo what Laura said there. Extent and duration of search. What I mean by that is there's lots of different ways to do redundancy processes, but your duty to look for alternatives for potentially redundant employees is right to the bitter end. So until their employment actually ceases. You could have gone through the consultation, served them their month's notice, but it doesn't cease at that point. If in that month's notice they're still working and 2 weeks from the end a vacancy arises, you need to be positively saying, oh, hello, potentially redundant employee, this vacancy has arisen. Are you interested? Because otherwise, again, you could fall down on that aspect of the reasonableness test. Is the alternative employment suitable, and what is the relevance of this? I find that employers and employees can sometimes get into a slightly curious argument about suitability of alternative employment. And a lot of the time it's unhelpful. And by that, I mean, in the core part of the redundancy process, the looking for an alternative role to avoid redundancy, suitableness only really comes up in a situation where the employee says they want to do something and the employer doesn't think they've got the qualifications to do it. And in that scenario, yes, the employer can say, we don't think that's suitable. We're not going to offer you that role because you wouldn't be able to do it. Fine. The only other context where it can come up is where there is a role that the employer thinks is suitable and the employee doesn't want to do it. That's entirely the employee's choice. Sometimes it's been suggested to me, are they just resigning then? The quick and short answer to that is no, they are not, unless they actually resign, which they almost always don't. So if you have a suitable alternative and you offer it to them and they don't accept it, that's their choice. And you either have to continue employing them on the role they're employed to do or continue and make them redundant. The only relevance that then that has at that stage after you terminate them by reason of redundancy, assuming that you do, is you could, and I say could, seek to argue that they've unreasonably refused an alternative employment, a suitable alternative role, and therefore they are no longer entitled, assuming they were entitled, to a statutory redundancy payment. But the test for that is quite in favour of the employee. So whilst it might be a suitable alternative role in one sense, that's different from whether they've unreasonably refused it. So that's I'm not intending to talk about the case law on that, but don't get in a tangle about are they resigning if they don't want to accept an alternative role. If you're making them redundant, they don't have to accept any role that they don't want to. If they want to take their redundancy payment and run, they can, subject to the caveat about the unreasonable refusal. And the final slide, bullet point on this slide, enhanced rights for employees on maternity leave. The eagle-eyed among you will have seen that on 4th of April, 6th of April, I can't remember which date it was, but it was in 2024, so it's definitely in the past. In April last year, the maternity and pregnancy enhanced rights to be offered suitable alternative employment ahead of anybody else increased. So before, the law said that if you had someone who was on maternity leave, they should be offered suitable alternative employment in preference to anybody else. And last April, that enhanced right was extended to anybody who is pregnant, assuming they've told their employer. So that's a tip for any employees on. If you want these enhanced rights, you need to notify your employer that you're pregnant before you get made redundant. And then that right lasts from the point of pregnancy to the point of going maternity leave, for the entirety of the maternity leave, and for a protected period, which is 18 months from when the birth, I think. I have to protect the guys who like, but the point I'm trying to make is that people have a lot longer period of enhanced rights. So you could have had someone who's been back at work a significant amount of time after having maternity leave. I say significant amount of time, potentially up to 6 months, and they still have this enhanced right. So you just need to be very mindful that you don't accidentally miss that. I could see an innocent mistake being made there. So careful of the enhanced rights. There's also enhanced rights connected to people who've taken adoption leave or shared parental leave that are very, very similar, or I should say the same. So we need to be careful of those workers, making sure they get offered suitable alternatives in preference to everybody else. And clearly, if you've got more than one people who've got the enhanced rights, then you go back to square one of choosing between them. So you sort of have a slightly strange ranking system there of the people with the enhanced rights and the people without. And then another thing to be aware of, from 6th of April this year, there's a new category of neonatal care leave, and you also get enhanced rights that are the same as if you're on maternity leave or pregnant if you've taken a sufficient amount of neonatal care leave. So that's another one to be wary of, which just makes planning all the more important in redundancy situations. Common issues. Back to the more mundane that you've probably come across, people being off sick, people on maternity leave. It's always quite difficult when you're doing redundancy consultation with a number of people when people can't, for perfectly legitimate reasons, attend meetings. And employers have the difficult job of trying to balance not rushing through it so those people that are on potentially sick leave or maternity leave can't engage properly with the process, with unfairly dragging it out for everybody else. So there's a balance there, and again, planning is key, and just trying to make arrangements so that neither party is disadvantaged. Employees wanting to leave during the consultation, Nick covered this, and Laura, to a certain extent, where employees think that redundancy process is just irritating and it's inevitably going to lead to them going. So can we foreshorten it and have the final meeting earlier, etc., etc. I generally seek to resist that, because especially if you're dealing with a number of employees, it's going to be strange if you're treating someone differently, and also that employee who say they want to leave could well then bring a claim and say, well, consultation was too short, and you'll say, well, you wanted it to be too short, but that, again, it's not going to be a very attractive argument. So it's better just to keep everyone in process and try to manage the impatient people in the same way you're managing everybody else. Grievances raised during the process. This is an old chestnut. I've actually had this come up on my desk the last couple of weeks, where somebody raised agreements alleging unfair selection and discrimination, but the discrimination didn't really say anything as such. It just used the word. So question mark whether or not that's really discrimination in the sense of a protected characteristic in the legal sense. Sometimes I've seen employers get spooked by a grievance and then pause the entire redundancy process to go through the grievance process, the grievance appeal, and then resume it, and then many months later finally get to the end of the redundancy process. That's not necessarily wrong, but if the grievance is entirely related to the redundancy process, it makes a lot of sense in those situations to just deal with the issues that are being called a grievance as part of either the consultation or any appeals process. And if there is anything genuinely separate, like I'm being bullied by this manager, and that's not why I've been picked, then that could be hived off and dealt with by the grievance process, so that often you can either deal with grievances that are linked or almost entirely solely related to the redundancy process as part of the process itself, or you can hive off what's actually a genuine grievance and deal with the two things at the same time, so that the redundancy process doesn't get sidetracked. Because if you've got a reduced requirement for a role, dealing with the grievance for 3 weeks isn't changing the timescales of when you do or don't need that role to be undertaken. And then back to Nick, I think, on restructures.
Thank you, James. Yep. Interestingly, I had a tribunal case, James's point on employees wanting to leave the consultation process early. Had a tribunal case where someone did exactly that, said, I want out, let me go early, and then sued for unfair dismissal. So yeah, it's not necessarily a given that somebody will not, pursue things after the process, even though they've asked to go themselves. And unfortunately, the way that the tribunal system is, we were in that process of defending the claim for way longer than we should have been. So yeah, good advice from James. Restructuring. So we wanted to focus on an aspect of restructuring. Redundancy restructuring often go hand in hand. Sometimes a restructure will lead to redundancies. Sometimes the terms are kind of used interchangeably, often not helpfully. But when it came to this section, given that we've kind of covered pure redundancy there, we wanted to look at restructuring a workforce in the sense of changing terms and conditions in the main. And it's probably helpful just to give you a quick reminder of how this works at the minute, and then we are going to look at some of the changes that are coming in the Employment Rights Bill, because this is one of the areas that we're seeing employers kind of missing the significance of in terms of the changes that are coming. And actually, it's very significant potentially if it proceeds on the basis that the government are suggesting. So, reminder of the current law. Dismissing an employee who refuses to accept a change to terms and conditions is potentially fair. It's an example of some other substantial reason dismissal. And this tends to be the situation where an employer wants to change T's and C's, starts a consultation process with staff, suggests it based on a good business case, says we'd like to change hours, for example, and this is the business reason why we want to do that. Please, will you agree? Often people will agree and they understand the business case for it, and that's all good. Contract varied by agreement. Sometimes they won't. And the fire and rehire part of this is essentially the kind of what I sometimes describe as the nuclear option at the end of that process, should the employee not agree to those changes. And that then involves the employer serving notice, so dismissing essentially on that old set of terms and conditions, and dismissing the employee and offering them a new set of terms with the change that they were consulting about. And then the employee can either walk away and be dismissed or accept those new terms. And of course, the walk away, be dismissed bit can also involve them then bringing a claim against the employer for unfair dismissal. And we would then be looking to defend that on the basis that it was a fair dismissal in the first place. When will it be fair? Well, where there's a sound business reason for the change. And again, I go back to the very beginning where I talked about business case documents for this. It's essential to be super clear on why we're proposing to make the change and what the business reasons for that are. Then also whether the employer has followed a fair procedure, and that's effectively the period of consultation that you took the employee through, similar to the redundancy consultation process, and generally where we're explaining why this is happening, what we're asking them to do, giving them opportunity to respond, and so on. And then the reasonableness of that decision in all the circumstances. So that lovely word that we all know and love in terms of assessing whether it was reasonable for the employer to do this. So that's kind of the background. What's coming is a fairly significant change, as I alluded to. And essentially, the Employment Rights Bill would make it automatically unfair to dismiss an employee if the reason that you're dismissing them is them refusing to agree to the variation in the contract. So pretty big in terms of removing that threat, I suppose we could call it, if an employee were to refuse to agree a change, because there's essentially very little we could do about it if you can't then serve notice and offer re-engagement in the kind of fire and rehire process. There is one exception to that, which is where, in fact, there's lots of words on the slide there, but essentially where the business is in financial difficulties and pretty severe financial difficulties, and the change that you're proposing to employees' T's and C's is necessary to save the business, essentially. Now, the challenge with that is most employers will not want to take their business to the brink and avoid making changes that would potentially help them in the hope that they can then fit within this limited exception. So again, we suspect that that exception, that defence to that new proposal is unlikely to be used that often. In terms of our view on the bill, does it go too far? Probably yes, I guess. And if actually it goes through in its in its current format, then it could have pretty significant impact on employers' ability to manage their workforce in a variety of scenarios. Now, often that might be where there's a two-tier workforce in terms of terms and conditions, where acquisitions have taken place or that kind of thing, and actually harmonizing those terms would be helpful. Not always easy or possible, but helpful. And that then means that would be virtually impossible without employees agreeing. And of course, if they cotton on to this, that effectively the employer can't really do much about it, they may be less motivated to actually agree in the first place. The other downside that we see is where actually the employer is looking to make changes which could be interpreted as more positive. So, for example, in a manufacturing setting where the employer is actually looking to grow and looking to produce more, and actually wants to move from a, let's say, two shift pattern to a 3-shift pattern, because actually they can produce more over a longer period of time, let's say with new technology or that kind of thing. Moving those employees that you currently employ from that 2-shift pattern to a 3-shift pattern would actually be incredibly difficult, given this potential change, if they didn't agree. And you know, there's practical difficulties there for employers for sure. In terms of practical steps to take now, though, we are already seeing employers looking at this ahead of this potential change coming in. Again, it's uncertain as to exactly when it will arrive. Some people are predicting this one might even be the autumn of this year, as opposed to 2026. But certainly, if you have a 2-tier workforce, as I described, or if you have benefits that you've kind of been looking at potentially reviewing, downgrading, whatever it might be, it might well be the case that it's worth you flagging that to you know, senior leaders within the organization now, because it's still possible to make those changes through a process of consultation, as we've described, where it might not be in future. There are, I suppose, a few other workarounds or consequences for this too, which might be to include contractual variation clauses in employment contracts, which give you more flexibility to change things from a contractual perspective. So yeah, workarounds, contractual variation clauses was one of those aspects. I'll just move the slides on for us. And essentially, the problem with the contractual variation clauses is that tribunals have taken quite a dim view of them, and essentially said that often they don't work. So that's going to be tricky. There's also a school of thought that suggests that you might also have to have a specific variation clause for every different term in the contract that you include, and that would make things very difficult. The upshot of all of that might well be that you'll be referencing the beginning of this webinar more regularly and just firing people. So redundancy might well be the only option that employers have in circumstances where they can't, you know, afford to continue to employ people, and might ordinarily have changed terms and conditions instead, and won't do that because they can't as a result of this change, and will make people redundant rather than risk, you know, automatically unfairly dismissing people by doing a fire and rehire process that you know, is going to cause them problems. So certainly worth looking at now from an employer's perspective for sure. James, I'm going to pass over to collective consultation. I suspect James might be answering questions in the chat. Hopefully you can fire that one off before he presents.
Yeah, I'm just typing. People are very keen to ask questions, Nick. You can pick up.
I'll pick that up now. Absolutely.
Some of my answers. You can disagree if you want. Collective redundancy consultation, which actually pings into one of the answers I just bashed into the chat. So the duty arises where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. That's as it was. I'm talking now about the current law, not the new Employment Rights Bill world. We'll come to that in a second. But
James, you might just need to take control of the slides. Sorry, I appreciate you jumped in after the chat.
Yes. Are we on the right slide? We are. Are we not? We look to be. Yeah, but this is the slide I'm talking about. Hopefully everyone else can see the one that says collective consultation with 2 bullet points. The second part, the wider definition of redundancy under TOCRA, that is if anyone's been reading the chat eagerly. So if you were proposing to dismiss and re-engage 100 or more workers or 20 or more workers because they wouldn't agree new terms, that would trigger the duty to consult under the Trade Union Labour Relations Consolidation Act, because you would be terminating people for a reason that didn't relate to their conduct or performance, even if they technically didn't come within the redundancy definition under the Employment Rights Act that Laura alluded to earlier about work ceasing or diminishing of a particular kind. So that's often one that catches people out. And also with fire and rehire, I mentioned the ACAS Code of Practice. That's just a bog standard application of a dismissal process. I wasn't making a nuanced or complicated point. It just applies to fire and rehire dismissals. There is also the relatively new code of practice on fire and rehire, which if you didn't follow may also lead to a finding of unfairness. And perversely, that code of practice that will soon be pretty much redundant once the Employment Rights Bill comes in, because of what Nick was saying about it being almost impossible to fire and rehire anyone fairly unless your business is about to die. That at the moment is sort of like a guide for how you actually do fire and rehire fairly. It's quite long-winded and step-by-step, but if you followed it to a T, you'd have a good chance of succeeding in defending an unfair dismissal case. So anyway, as I said, fire and rehire would come under the wider definition of redundancy under the first bullet point, not related to the individual concerned. Collective consultation, consider applicability at the planning stage. We've talked a lot about redundancy processes going well if you plan, and collective consultation needs to be factored in. How many people are we proposing to dismiss as redundant? And at the moment, it's not too hard, because you're just looking at one establishment, you're counting up the numbers, and you're looking at a 90-day period. As I'm going to come to in a minute, that changes soon, which is going to make the planning all the more important. Similarly, the risk of protective award, that's going to become riskier because it's going up. And number of additional obligations, the reason you need to factor that into collective consultation is because it just slows everything down. For those of you not familiar with doing collective consultation, in section 188, subsection 4 of the Trade Union and Labour Relations Act, it lists out a whole load of stuff that the employer should disclose in writing to appropriate representatives at the start of the consultation process. Things like the reason for the proposals, the number of description of the employees affected, how we're going to choose between workers to make them redundant, how redundancy payments are going to be calculated. I won't list them all. Even information about agency workers. And that's one that people often miss, because they say to me, well, we don't use agency workers. But that doesn't mean you don't have to tell them that you don't use agency workers. It's quite a pedantic and prescriptive process you need to go through with collective consultation. And the other thing that often takes time, especially for sort of small and medium-sized employers, is if you don't have a recognised trade union and you don't have a standing body of employee representatives pre-elected for the purpose of collective consultation exercises, then you have to elect appropriate representatives, and that of itself takes time before you even get started on the 30 or 45-day period, which you must wait before redundancy dismissals can be effective. So you really do need to get your ducks in a row, otherwise you could be waiting a long time before you can move through the process without risking big protective awards of currently 90 days gross pay per employee. But I say currently because that brings us neatly on to the changes and why collective consultation is going to become more common, and why we're all going to have to get used to doing it in the future. And that's because the Employment Rights Bill has evolved since its original publication. And in some ways, these things might appear to be positive, and others negative from the employer's perspective. And those that came to our update at Cleaver and Wake not so long ago might notice that this is all different now. So what we said was right at the time, but the government have since changed it. So bear with us on that. So the one thing that I talked about last time was the going back to the Woolworths case and the establishment test being abolished. Now, that was particularly unpopular, and the response to the bill was relatively negative. So the government have flip-flopped on that, and the single establishment still exists. So it will still be a trigger for collective consultation where there are 20 more people or employees at a single establishment who you propose to dismiss as redundant within 90 days. But the way that this is being extended is now going to be different. There's going to be an additional test that will trigger the obligation to consult under this piece of legislation. Now, as is a common feature with the Employment Rights Bill, they're not going to tell us precisely what that is. It's going to be snuck away in some kind of regulations at some point. But it's clearly going to be increasing the need to do this for scenarios. And it's going to be some kind of threshold, either a number of employees presumably in the ballpark of 20 and 100 or more, or some kind of percentage of the workforce that will trigger the obligation. So I don't know, 10% of the workforce, but risk of redundancy triggers the obligation, or 5%, or who knows what it will be. And this other threshold won't worry about the single establishment. It will aggregate across the employer as a whole. So that's what's going to make it a bit trickier. And as I'll come to on the next slide, that's going to mean more planning and record keeping across our company as to how many people have been made redundant and where and when, so that you can work out when your obligation to collectively consult applies and doesn't apply. One of the biggest criticisms that was levied when the original bill came out, and people were saying, well, isn't it ridiculous if I'm making one person redundant in Somerset and 21 redundant in Newcastle, that I have to collectively consult the one person in Somerset? And if they're working at completely different places, so factory A and factory B, it's not going to have any overlap. So why am I having a single consultation exercise about two entirely separate decisions? And the government have listened to that, and they've said that you don't need to necessarily consult all the employee representatives together or come to agreement collectively on the same points. So you could, in a sense, be running two parallel consultations at the same time under this duty that don't have anything to do with one another. Now, you could query, well, what's the point in that? Well, that's a different debate, but at least you haven't got this slightly ridiculous situation where you're trying to talk to two sets of people who will be completely disinterested about the other part of the business potentially. So that's a bit of a concession, albeit it still broadens the obligation, which is clearly the aim of the parts of the bill that are changing. With that in mind, the protective award is going to go up from 90 days to 180 days pay per employees. I suspect the reason for this might be linked to one of my old talking points, the P&O case, because that was the case that had nothing to do with fire and rehire, that everyone talked about it being fire and rehire. And what they'd essentially decided to do was just pay out a load of money based on what people could sue them for and not follow any kind of process. And so if you were to take that approach with a protective award of 180 days, it would be twice as expensive, broadly. And so that's one of the reasons why they're increasing the protective award, is to further disincentivize people saying, well, we don't care about the law, we'll just pay out the 90-day award. So if those changes come in, which seems highly likely, what will the practical impact be? Well, we'll need to do this more, hence us having a webinar on it, just to get everyone back into the frame of mind for doing collective consultation, because it hopefully for most people doesn't come up too much. Increased risk of non-compliance, so the penalties are a lot more. And perhaps the biggest practical impact is this one: keeping count will become critical. There is some old European case law which hasn't been firmly poo-pooed by our courts yet, that talks about counting forwards and backwards. And what I mean by that is, if you make 5 people redundant and then subsequently make 25 people redundant, did you fail to consult the first 5 if you didn't go through the collective consultation exercise? And this case suggests you probably did. And a lot of people disagree with that. And one of the things that most lawyers were hoping for in this employment rights bill was for the government to specifically legislate that you don't have to count backwards as well as forwards. And so things that were already subject to consultation when the duty wasn't triggered can't then retrospectively be dragged into it. That comfort doesn't exist yet. We can live in hope until the bill comes in to law as an act that they will fix that loophole. If not, we have to be very, very mindful of numbers and consider the possibility that previous exercises of redundancy may subsequently be triggered as a collective consultation exercise after the fact, if we've not managed to have our 90-day windows completely clear of the sufficient thresholds, whatever they will be. I'm going to hand back to Nick just to tidy up.
Thanks, James. I think there's just one question I didn't get to in the chat, if you want to pick that up, James or Laura. So just to finish, we thought it might be helpful just to look at a couple of areas or a few different areas that haven't been covered elsewhere in the session as a kind of just a wash up. Feel free to keep posting questions. James and Laura will look at those as we go. The first of the issues that I want to just touch on was, is it genuine? So is the redundancy process genuine? And I think this is one of the challenges that employers face when managing these kind of processes, that employees will often say, well, this isn't necessary. I don't believe that this is real. It's a sham. You just want rid of me. And we'll really push back against that. And I guess that's part of the reason that I always focus on the business case document, so that you can share that with them and you've thought about the exact reasons behind this before starting the process, so that you can address that. The other thing that's really key to demonstrating that it isn't a sham, it is following all the guidance that we've talked about today in terms of consultation and going into the process with an open mind that the individual, the employee who's affected by this, who's at risk, might actually come up with something that's relevant. That might change things. Now, often that's not the case, because employers generally are savvy enough and sophisticated enough to have thought about alternatives to the process ahead of kicking it off. And of course, the PR and the legal risks involved in such a process are high anyway. So generally, employers don't go into these things, without having thought that through. But giving the impression, at least, that there is the potential that this person isn't going to be dismissed on grounds of redundancy for sure as part of this process is helpful, and will improve the chances that you take your employee through that journey in a more sympathetic way, and in a way that helps them understand why this is happening. So that's one tip, I think, and one other thing just to think about and to encourage managers to do well. Now, I appreciate there are circumstances where that's difficult because it's, for example, a full closure of a site and there are no other alternatives, and I get that. And often, it's better to be realistic about that as a process. But where that's not the case, being genuine about it will help in those circumstances. The other thing that I wanted to talk about was outplacement, just very briefly. James and I were talking about how over the years, this has kind of gone in and out of fashion to the extent that some people may not even know what outplacement is. And essentially, it's support for employees after they've left you to essentially find other work. So usually it involves things like assistance with CV or interview technique or things like that. And it's really useful from a number of perspectives. The first being that it's something that the employee may well value when they're faced with losing their job. And if that's something that will reassure them about their future employment prospects, then clearly that's useful and helpful when it comes to reassuring them about the process. The other side to it is that if they are able to find another job after they've left you, then clearly the risk from a financial perspective, should they bring any claim, is decreased because they found other work, and therefore that might well be useful as well. I think the other thing just to consider in these circumstances is whether you might shortcut the process. And we talked about the dangers of shortcutting the process where the employee asks to leave during the consultation, but actually it may be that as a employer you are prepared to offer enhancements to the standard redundancy packages that you offer in order that you can effectively bring the process to a close more easily or more quickly, and minimize risk too by also potentially offering settlement agreements, which would protect the company against any claims. That is possible to do. Usually if you're paying additional money over and above, that would be helpful to do, but it may not be something that's possible to offer as part of the process. So yeah, enhanced redundancy payments might be something that you want to consider if actually you want to look after people, or want to minimize risk by getting settlement agreements in place. I'll post a link to a webinar that we did on protected conversations, which might form part of this. But actually, some employers are just very open about the fact that they're enhancing redundancy payments because they're looking after people. And it's done on an open basis for people to accept if they want to. So it's definitely worth considering. It does minimize legal risk if settlement agreements are in place, obviously, because employers can't be sued off the back of that exercise. But it may be that actually you're making people redundant because the business doesn't have a lot of money, and therefore paying extra money to individuals leaving just isn't an option. So but it's certainly worth thinking about. That pretty much brings us to the end of the session. We'll just have a couple of minutes for questions as we go. We do provide what we call a redundancy pack, which is all the letters, templates, meeting notes, templates for those, business case documents, all that kind of stuff, which if you're running this kind of process can be really helpful, because as you'll have picked up, it's incredibly procedural and it's very easy to fall down on the procedure if the right letter isn't sent at the right time and the right meeting notes aren't taken, and so on. We've been running a free employment contract review for a little while now as well, where we'll effectively check your contract for legal compliance. There were a number of changes probably 4 or 5 years ago that people I think have still missed, and obviously there's some stuff to come too, and we'd happily produce a report just letting you know where the gaps might be in your contracts if that's helpful. And the other thing, with a lot of the changes that are coming, we're seeing employers focusing in on training up managers, upskilling managers to deal with these kind of situations well. Performance management, redundancy, disciplinaries, grievances, that kind of thing. And particularly with the unfair dismissal day one rights coming in, getting managers managing better is really important. So we're working with a lot of clients running training that's really accessible for managers, that they will understand, that is very case study based, in order that they get better at this stuff, which will hopefully avoid risk down the line when actually there's likely to be more claims, and certainly unfair dismissal risk in a lot of different scenarios. So that's pretty much us. I'm guessing James and Laura have picked up the outstanding questions in the chat. If there are any more, then please do pop them in there. And if you want to unmute, I think that might even be possible, and ask us a question, that's also fine. And we'll give it a couple of minutes for people to do that. If not, we'll see you next time. Really pleased that you could join us, and apologies for my technology issues at my side. We'll stay on just for a few more minutes, just in case anybody does have any final questions. But thank you everybody for all your thank yous. Okay, I think that's probably question time done. Thanks everybody. Hopefully it was a useful session. Do connect with us on LinkedIn if you haven't already. As I say, I know people have differing views on whether they like LinkedIn or not, but it is a great way for you to keep up to date on what's going on at the minute, and it might well be that you pop there a bit more often at the minute, just to keep up to date on what's happening. So feel free to connect, and we'll see you next time.